Welcome to the latest episode of Called to the Bar, International Law Over Drinks. I'm your host, Douglas Guilfoyle, Professor of International Law and Security at UNSW Canberra. Today we are discussing the dramatic series of events that resulted in former President of the Philippines, Rodrigo Duterte, being transferred to the custody of the International Criminal Court. And unlike certain judges of the International Criminal Court, I believe I got the pronunciation of his name right, which is always a great place to start. To discuss the case and its implications, I am pleased to be joined by Ruby Rosel Ross Tugade, Filipino lawyer and lecturer and incoming PhD researcher at the UNSW Faculty of Law and Justice, and Dr. Priya Pillai, Executive Director of the Asia Justice Coalition. But before we begin, I remind everyone that in these informal conversations, we are, as always, speaking off the cuff and without benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. And before we get down to today's subject, we have our traditional opening questions. So first, everyone, noting the hour on a Tuesday afternoon or a Tuesday morning where Priya is, what's your drink?
Tea, Darjeeling.
Mine's a Coke Zero.
Coke Zero. I think that's our first Coke Zero for the podcast. I forgot to bring any kind of fancy soft drink into the office today, so I'm having green tea from a teapot I discovered needed a really thorough clean. So apparently I need to be making tea more regularly in the office. In any event, we usually start these episodes by asking new guests, how did you get into international law? What career path brought you to your present job? Ross, can we start with you?
So my first job out of law school was with the Human Rights Victims Claims Board. It was the transitional justice mechanism of the Philippines for the martial law regime. It has since been defunct since 2018. And then after that, I went to the Commission on Human Rights just in time for the peak of the drug war during the Duterte administration. So my early years as a lawyer was marked by one atrocity event in the past to an ongoing atrocity event at the time. After the CHR, I went to Center Law, whose lawyers are also accredited to practice in the ICC. And then after that, I went to Partners in Justice International, doing international criminal law work, and then ended up in the academe in the UP College of Law, teaching international law, of course.
Right, goodness, yes. So you've obviously had a lot of pretty frontline and very topical experience that's relevant to what we'll be talking today. So we'll come back to that. Priya.
Douglas, how much time do you have? It's been 25 years, so I think I'll just talk about maybe the spark that lit, I think, my interest in law school, which was really working on international law through Jessup, working on a moot that involved these issues. I think in terms of maybe past background as well. I think living as a child in Iraq during the Iraq-Iran war certainly sort of made me wonder and talk about, what causes wars, why do states have conflict? I mean, I think those were childhood sort of discussions that we had. And my dad was in the Navy. He led a peacekeeping force for UNOSOM, Somalia. So I think those were really childhood experiences and discussions that we would have over the dinner table that then made me realize that this was an area that I wanted to focus on. And then it's been a zigzag path, honestly. It's been 20 plus years of really struggling, ups and downs. But I think for me, the pivotal career experience really was working at the UN War Crimes Tribunal for Yugoslavia, really in its heyday, in the early 2000s, when things were just starting off, when international criminal law was really in its infancy as well. And I think that's had quite an impact on sort of all my steps after.
Yeah, that certainly sounds like a frontline seat at a very pivotal moment, but also it's remarkable how commonly the Jessup moot comes up as a sort of turning point in people's interest towards international law. Okay, well, I'm really pleased to have two people who are so versed in the front lines of international criminal law practice joining us today, because otherwise it would just be me with my academic desk-bound view of what's going on in The Hague at the moment. So let's kick off our discussion about the case against President Duterte and his transfer to the ICC. So my first question, I guess, particularly for those who are non-experts in the field, is what are the charges against President Duterte and how do we know? And how did the ICC's investigation into his actions as president and also mayor of Davao City unfold? Who'd like to start? Perhaps Ross.
So the publicly available warrant of arrest, as well as the request for the issuance of a warrant, initially stated crimes against humanity of murder, torture, and rape, but the chamber did not find sufficient evidence to proceed with the rape and torture counts. So the confirmation of charges will be for crimes against humanity of murder, the trial later on. And the crimes against humanity of murder covers two geographic spans, if I may put it that way, and temporal periods as well. The early one is for his mayor post or stint in Davao City. That's in the southern part of the Philippines, where he led the Davao Death Squad. And then later on as president of the Republic of the Philippines, where he sort of magnified or escalated the system that was already in place in Davao and then executed it on a national level during his presidency. He was president from 2016 to 2022.
Okay, terrific. Priya, is there anything you'd like to add from your point of view here?
Yeah, just one little footnote, and I think this is going to be interesting to see how it unfolds. But as Ross said, the initial arrest warrant did include torture and rape and murder. If you look at what the arrest warrant actually says, the judges have basically said that there's the nexus between alleged acts and the attack, so widespread and systematic, is insufficiently shown for torture and rape. So I think it's still possible for the prosecutor to bring this up in confirmation of charges, but maybe this is a hint that they need to get more evidence and they need to make that nexus clearer to make it possible to confirm charges like this. So I think that's something that still may be possible. I don't think the door is closed to that.
Right. And again, for any general listeners, the essence of a crime against humanity is that there needs to be a widespread and systematic attack against a civilian population. It's the same under the Rome Statute of the International Criminal Court, and then that certain crimes have been committed that are linked to or part of the broader course of conduct that is that widespread and systematic attack. And a point we'll come back to later in our discussion, I think, is he's actually been charged with involvement in relatively few, still a very large number of murders, I think 43 individuals. And we'll come back to why he's been charged with a number less than the several thousand people or more who are thought to have been killed in the course of the war on drugs. In any event, before we get, as it were, to the courtroom, there are a couple of other sort of background questions we should probably cover. So for those who aren't specialists in international criminal law, people might have some sort of recollection that the Philippines, in fact, left the ICC. So how did that come about and how does it still have jurisdiction? Priya, would you like to begin this time?
Sure, Douglas. Let's go back a few years before that, right? So the Philippines was actually one of the states that lobbied quite hard for the Rome Statute, was extremely involved in discussions around the Rome Statute, worked, you had civil society in a campaign in the country to make sure that the state finally signed and ratified, which happened in 2011. Now, a preliminary examination was announced in 2018, linked to the war on drugs. And in response to that, the Philippines, the government of the Philippines announced its withdrawal in March 2018. Now, withdrawal takes 1 year to take effect. So essentially, the cutoff date is March 2019. And, it's quite clear when you look at the pretrial chamber that then authorized an investigation in 2021 based on a request by the prosecutor, who essentially said, look, we've got enough to move forward now, that this is very much confined to the period of 2011, from when the Philippines ratified, till 2019, literally 16th March 2019, the cutoff date. So the court essentially is saying it has jurisdiction, but within that time period, till the time that the Philippines actually withdrew. But the issue is that these were crimes that were committed during that period, and so therefore the court has jurisdiction in this case.
Ross, anything you'd like to add on that point?
Just perhaps on the domestic law aspect of it, because this is very interesting, as this reflects how the Philippine Supreme Court has interpreted this point of international law. For the Philippine Supreme Court, when a case was brought up on the legality of the withdrawal, the Philippine Supreme Court, in this case called Pangilinan versus Cayetano, said that essentially it is moot and academic because only the president, as the chief architect of foreign policy, can decide on the treaty withdrawal. And at this point, since the process has unfolded and the withdrawal has taken place, there's nothing left for the court to do or to decide anymore. But interestingly, in Pangilinan versus Cayetano, the court went through this long exegesis of the relationship between international law and domestic law. But all of this is obiter. I mean, for us who went through the law school system, we know that this has no doctrinal binding effect. But the court essentially said, well, we do have a domesticated version of the Rome Statute, Republic Act 9851, and that should be sufficient for protections against international crimes should the need arise again in the future. So at this point, it is all moot and academic.
Interesting. And the Philippine Supreme Court's been very active, it seems to me, as an outsider on questions of international law, including in the South China Sea dispute. But, and Ross, I'll stick with you for the moment, because again, for the outsider, the circumstances of former President Duterte's surrender to the ICC seem pretty dramatic and certainly made international headlines. So what were the facts, and are there any due process implications here?
So it was, as you mentioned, quite dramatic. There were hush-hush whispers a few days earlier from the arrest that President Duterte was already in Hong Kong and a warrant is forthcoming in terms of its implementation. So there were a lot of informal discussions that he might escape, evade the issue, the implementation of the warrant. But again, from the rumor mills, different versions. But if we just look at what unfolded in the news, he returned from Hong Kong with a lot of his associates and including his daughter, the current vice president of the Philippines. And then there were already around 7,000 policemen deployed in the airport. At least that was a number reported in the news, ready to arrest him anytime. And so the arrest...
No, just to interrupt for a second,
Yeah.
7,000 policemen?
Yes, 7,000 policemen.
That suggests they were expecting
Yes.
potentially quite a bit of trouble, not just from one moderately elderly former politician, right? So what was the concern there?
And this is where it's quite interesting because the Duterte support base, at least politically, is still very strong and almost solid. If you look at what has happened after the arrest, a lot of demonstrations, protests in support of him. A hashtag has been used as a rallying point, hashtag bring him home. We've been seeing that. So 7,000, quite a large, ridiculously large number for an arrest. But I think the political circumstances surrounding the arrest would have, in a sense, justified that use of law enforcement personnel to secure his arrest. So the events unfolded quickly. He was whisked off on a plane. His daughter, his youngest daughter, was posting a series of Instagram stories. So I'm not sure this probably is the first international law criminal event that unfolded in real time on Instagram stories. So from the moment of the arrest up to the whisking off of President Duterte and the plane taking off from Villamor Air Base, it was all documented, and we saw that the whole dramatic atmosphere around it in the news.
So, I mean, two facts that I'd heard in other commentary were that one, he was sort of turned around and put on another plane, a privately chartered plane, so fast that his own lawyers couldn't get to a national court in the Philippines, and that perhaps all of this was also timed to, as the police presence suggests, prevent supporters mobilizing. But on that sort of second point, is there a due process issue here with this sort of fairly sudden surrender straight from an airport?
So it's quite interesting that during the flight to The Hague, there were court filings that were happening. So it seems that the Duterte camp was ready to challenge this with the Philippine Supreme Court, but it all happened so fast that the court had to decide quickly and act on the petition for an injunctive relief filed by one of his close allies. And even false information that the Supreme Court had granted the TRO was circulating that night in Manila. But the Supreme Court did not grant the temporary restraining order. A second court filing was also filed by the children of President Duterte, a habeas corpus petition to challenge the legality of the detention of President Duterte. No decision on that. So the due process issue appears to be on the circumstances of the arrest and the detention. And that has been a recurring discussion in the past 2 weeks in the Philippines. But I think what is quite ironic here is due process seems to be the hook or the anchor for the Duterte camp. And the due process has been, an issue that has always been a sore point during the drug war. Killings, arrests, practically no due process. So, supreme irony here is Mr. Duterte himself is claiming that he was denied due process.
Right, when he's never been a particularly big fan of it in the case of other people. Priya, did you have any observations on this point?
I mean, I think just to re-emphasize Ross's point, this whole issue of due process. I mean, not to say that people should not be afforded due process. I mean, I think we all agree with that. But I think the weaponization of this, in sort of the political arena is really ironic. And I think, if I recall, and I think Ross will again be able to, correct me if I'm wrong, but one of the government spokesmen actually said that we waited for 12 hours. We waited for this TRO to go to court, to go to the Supreme Court, for the Supreme Court to actually respond to it before we allowed the plane to take off. So I think government of the Philippines probably also was, well aware that this would be an issue and that this is something that they needed to tick the box as well, no matter what the politics were behind this arrest and detention. So I think there's supreme irony in this being a rallying cry in a way.
Interesting. And interesting that both sides, and I guess we'll dig into this a bit later, were prepared for this in advance, it would seem, with both in terms of the government approach and Duterte's readiness to go to the Supreme Court, which I guess does kind of lead me to my next question, considering how things played out in the Philippines. So why now? Why was Duterte surrendered now? The ICC investigation opened in 2021. Duterte's been out of power since 2022. If the new government was interested in surrendering him, it could have happened earlier. So what changed in the mix in Philippines politics to prompt this?
So the current president of the Philippines, President Ferdinand Marcos Jr., ran with the daughter of President Duterte in one ticket. They were dubbed the Uni Team. So the strongest contenders at the time joined together to run for the two highest offices. It was quite a solid partnership up until there were a lot of differences already, and there was a sharp, palpable pivot to now focusing on Vice President Duterte, investigating certain allegations of misspending during her time as Education Secretary. So she is also facing an impeachment complaint right now in the Philippines. The politics there is quite apparent that there is now a divide between the president and the vice president. We can speculate all day what could be the motivations politically, but it is clear that the unity team is no more. And so it was politically easier for the Philippine government to implement the warrant of arrest, especially since Mr. Duterte, the Duterte brand, has been quite under a series of political controversies in the past year. And also, I would like to point out that there is a very interesting way of how Malacanang or the presidential palace has framed this on the basis of international obligations. If I'm not mistaken, the presidential spokesperson said Well, we still maintain our position that we will not cooperate with the ICC, but we didn't say anything about not cooperating with the Interpol. So,
Huh.
what appears to me here is that, okay, they implemented the arrest warrant from the ICC, but the president himself said on the night of the arrest, well, it doesn't matter if it's a warrant from the ICC. We're merely implementing it, and our obligation right now is with the Interpol.
So that, I mean, that is a very interesting framing, isn't it? That no, we've left the ICC, we're not going to reverse course on that, and we're not even conceding necessarily that the ICC per se has some kind of authority, and plainly, as we've already said, it still has temporal jurisdiction over the period when the Philippines was a member, but instead we're going to hang our hat on the legitimacy of Interpol. And this element of kind of a struggle between two dynastic families in Philippines politics brings to mind the international relations principle of the two-level game, that sometimes when you can't resolve things at the level of national politics, it's easier to escalate it to the international level. But we more commonly see that with things like, intractable maritime or land boundary disputes, where you avoid peeving domestic constituencies by seeming to give in to your opposition by saying, oh, well, we had to do it, it went to an international tribunal. Here we're just kind of taking the entire political issue of President Duterte and handing that off to the international level. So obviously this occurs against the backdrop of the war on drugs in the Philippines. How has this move been received by civil society and victims? Is it seen as a positive thing, or is it seen as an abrogation of accountability that should be occurring at home?
This is quite interesting, Douglas, because for the longest time, people have been saying, oh, the ICC is an infringement on our sovereignty. So why are we allowing essentially a foreign entity to get a hold of our president, who was popularly elected by a very large mandate by the Filipino people, quite popular even after his presidency, allow him to be jailed in The Hague alone? And isn't that an insult to all of the Filipino people? But, and this is my experience now, putting my hat as someone who has been in the front lines, as you've said, when you talk to the victims, the victim families and the civil society organizations, this is quite welcome. And they don't see this as an utter failure of the justice system, not necessarily so. That is not a talking point primarily in the victim community, if the arrest would be an insult to the country. But the concern there is really seeing some sort of accountability, some form of resolution to what happened to their families all those years ago. I mean, it has been less than a decade, but justice at home right now is quite difficult. So any form of justice is welcome for the victim families. At least the ones I have talked to, that has been the sentiment.
Thank you. Priya, do you have anything to add on these points?
I think maybe just to add a little bit to Ross's point on, this pivot. And I will point out that the domestic legislation, and the government of the Philippines has actually referred to this as well in their argumentation around, Duterte's arrest and sort of extradition to The Hague, if you will. RA 9851 also has a provision which basically, has been called reverse complementarity in the Philippines courts, which is basically that there's this domestic jurisdiction which has essentially taken in and implemented the Rome Statute within the Philippines. But let's keep in mind that it was actually pre the Rome Statute ratification as well. So it incorporates the Rome Statute, and it has this provision which basically says that Philippine courts could allow an international or regional court to try or to prosecute crimes, grave crimes such as international crimes that are within the purview of the Philippines as well. So this is, again, something that came up very strongly in the arguments in the Supreme Court around the withdrawal from the ICC and what this meant. And the government is sort of using it now as well to say, look, but we in any case have this in domestic law. I think aside from that, to Ross's point, the arguments that have also come up in the Supreme Court during withdrawal, but also if you look at the appeals chamber decision on, on the resumption of the investigation, when the government of the Philippines basically tried to scuttle the investigation at the ICC, is sort of a detailed analysis of what's been happening at the domestic level. What has actually been happening in terms of trial courts? Have these cases been prosecuted effectively? And if you look at even the ICC chamber decision, you've got a discussion of the writs of amparo, you've got a discussion of sort of the Philippine National Police, you've got a discussion of these 3 or 4 different efforts in a way, and the court found that they all fell short, that they were not enough, and that they were not sufficient to say that the Philippines was actually fulfilling its obligations under the Rome Statute. So I think we've got to keep that larger context also in mind when we look at what the Philippine government is arguing right now.
And I think the concept of same conduct, same person test in ICC processes has also come up in terms of what the Philippine state has been doing in terms of its investigation efforts during the attempts of the Philippine government to state that there's no jurisdiction, it is not admissible. They pointed out to what Priya mentioned, these protective writs petitions, which are not criminal investigations by their nature. The Philippine state also submitted certain investigation files from the National Bureau of Investigation, but there were no cases filed in the prosecutor's offices. No criminal cases that would try for crimes against humanity under RA 9851, just isolated cases of murder by police forces.
Right, terrific, thank you. And again, for non-specialists listening, the ICC's approach to what's called the same person, same conduct test of complementarity. That is, has this case already been tried in another forum or thoroughly investigated in another forum in a way that would bar the court's jurisdiction? And correct me if I'm wrong, Ruby and Priya, but my reading of the ICC's jurisprudence is that they take a fairly strict view of same person, same conduct. So it's not enough to prosecute someone for a couple of murders as murder under a domestic statute. You really do need something that matches the kind of crimes and charges found at the international level. All right, so that does bring me on to the next thing I wanted to talk about, which was that the arrest warrant seems to signal a narrowly framed case involving a very limited subset of the reported 6,201 people killed in the Philippines war on drugs. And that's the official number. So the real number could be, as I understand it, much higher. What does that framing tell us about the current prosecutor's strategy and any lessons learned from past cases? Priya, I might begin with you this time.
Douglas, I mean, the first thing I would say is just on the numbers, right? So this is something that has been a bit disputed. There's been a bit of confusion around it. But I think it's important to note that the government of the Philippines now is going with the number that a lot of civil society and lawyers have been saying, that it is closer to 30,000. It's not, 6,000. It's actually a much
that's a big
higher
jump. Yes.
Yeah, and in the press conferences, and I was sort of watching all this live as well as it was unfurling. The government spokespeople actually used the 30,000 number. So I think there's a bit of an admission there that it is actually much more than the sort of effort to minimize these numbers. And let's remember that these are individuals who've been gunned down in the streets with no due process, with on a very flimsy basis. And so I think just speaking from being in the Philippines at the time during when this all unfolded, and Ross, I don't know if you know, but I lived in the Philippines for a few years as well, through 2016 to 2020 actually. There was a palpable chill in the air. People were really scared. There was a chilling effect on civil society, on lawyers. And I mean, I just want to say at this point that this has all happened because people have put their necks on the line and done the really hard work in the country. You've had lawyers, civil society, journalists who've reported regardless of the threats against them and who've actually made sure that this information has gotten to the ICC. So it's wonderful. It's fantastic that the ICC is moving forward. That is what needs to happen. But I think what's happened before and the preparation before when these political winds have changed is really, really important. And I think that's something that we need to emphasize. Now, I think specifically on the arrest warrant and sort of what the prosecutor seems to be doing moving forward, the arrest warrant seems very focused and obviously very tailored to Duterte's culpability, as it should be. And I think important to note that this also covers the period where he was the mayor of Davao. And essentially, you could say that was his practice run in a way for what he unfolded as president in Manila. And I think the linkages between sort of organizational policy as mayor of Davao, the sort of national policy and plans that he had in place in Manila, many of which are recorded, which are public. I mean, he made very, very explicit public statements, essentially, and one of them I will never forget, where he basically said that I will fill Manila Bay and the fish will basically feast on, on anybody who falls foul of this. So it's quite focused, it's quite targeted. But I do think that it is also linked to the jurisdictional aspects, obviously, of what the court is looking at. And I think let's look at what happens in the confirmation of charges. Because yes, while right now the arrest warrant is focused on murder, as I said, let's see what the prosecutor brings forward and what charges actually confirmed. And I think September 2025 is the deadline now for confirmation.
And just perhaps on a practical perspective here, when we're trying to prosecute crimes against humanity, at least from what I learned in the field in my short years of practice, that there has to be a clear establishment, not just of the specific crime evidence, but the wider context as well, and the linkage to the wider organization. So if you read through the request for the warrant and the warrant of arrest, they refer to a common plan, which is probably how the organization is structured, how the rewards or incentive systems are rolled out within the perpetrator group. And I think the focus on 43, there has been a lot of misinformation in the Philippines saying, oh, this is not enough. But I think as a matter of strategy, and again, this is speculation, what is probably important here is to look at the fact that there are certain geographic spans and temporal periods where the killings have peaked. And you can identify the perpetrator group, say a particular police precinct or a particular regional office of the Philippine National Police, are linked to all of these killings that happened in a short span of time in a particular geographic period. I think that is one way of building crimes against humanity cases that could be at play here.
Yeah, and so summing up again for non-specialist listeners, I mean, one would be inclined to say, sitting on the sidelines, 43 people sounds like a mass murder. It doesn't necessarily sound like a crime against humanity, but that's not how the crime is structured. So the crime, as we've said before, the prosecutor will also have to prove the existence of a widespread and systematic attack against the civilian population. That goes to the tens of thousands of people who died in the course of this. But then you prove against a particular individual a subset of those crimes where you can clearly and directly link them to it. And if you attempt to make the grand case, which may yet be coming, that through command responsibility or some other form of leadership accountability, that the individual at the top is responsible for the whole tens of thousands, that may be a noble aspiration, but it can be a high evidentiary threshold to clear. So it's not an uncommon prosecutorial strategy to start with what you can most obviously prove and build up from there. Which does sort of bring me to my other question that I wanted both of your reflections on, which is that if we look at the ICC's track record against sitting or former heads of state, it hasn't been that great. The ICC seems to have struggled to prosecute in the situations arising in Kenya and Cote d'Ivoire in particular, one involving a sitting head of state and one involving a former head of state. So do we have any reflections on whether this is likely to go better than that? Like have lessons been learned in this case, do we think, from those previous difficulties? Priya, could I start with you?
But Douglas, just quickly pivoting to the last point, I mean, it's linked, I promise, but just on the indictments and the charges, I mean, I'm just thinking back to Milosevic and the ICTY. So you had three massive indictments that were really, really, I think, unwieldy. And there's that balance of needing to hear survivors and ensuring that the entirety of criminal responsibility is captured. But then also, I think the practical aspects of age, infirmity, time it takes to go to trial, how you're going to manage that. And in Milosevic, we saw that literally just a few months before the final judgment came out, Milosevic passed away. And I think that should be something, again, speculation, but that should be something that the prosecution is also thinking about in terms of moving this forward, and being quite surgical, maybe in a way, in how they approach this. So I think lessons learned from Kenya and Cote d'Ivoire, slightly different situations as well. So let's be clear that in Kenya, the political situation, and Cote d'Ivoire, the political situations were such that you had both were post-election violence cases, both were situations where multiple parties, including opposition parties, were also accused of election violence. So I think to the extent of the incentive to cooperate, or the incentive to allow the ICC in, to ensure that there was no witness tampering, which happened in Kenya, one of the first charges that actually went through in Kenya was on administration of justice, on corruptly attempting to influence ICC witnesses. This is the Gichero case, which then was terminated with his passing away as well. So you've had those two instances where you had, opposition and those in power who were also implicated. I think the Philippines is a little different now, where you essentially have the situation where potentially you could have greater cooperation with the ICC. And I think just to say that in the last few months, just watching what's happening and the statements that have been coming out of the Philippines, the government has been basically saying, well, yes, we're willing to cooperate, sort of vacillating, going back and forth a little bit on that, so not really closing the door. So I think the question of witnesses, evidence, how we bring that to trial, that might then be eased a little bit in this case, depending, based on the political context right now. But I think very specifically on charges, I would look at Cote d'Ivoire, because you've got acquittals here. And you've got acquittals that have been confirmed by the appeals chamber, and acquittals on crimes against humanity. So to the point that you're talking about, I think the appeals chamber basically found that the evidence against the accused had been, and in their words, and to quote them, exceptionally weak, because a lot of it was circumstantial evidence, that they were not convinced that there was a pattern of crimes from which a policy could be inferred. There were no patterns of violations that they could find based on the evidence. So essentially, a lot of the evidentiary requirements were not met, seemingly in the Bagbo case. So I think, again, that's something that the prosecutor will obviously be looking at and learning from quite carefully as they move forward. But again, all speculation. I do not work in the prosecutor's office, but this is the way I guess I would approach it a little bit.
Yeah, well, two points out of that before we go to you, Ross. The first thing on timing of a complex trial. In Australia, a contested murder trial can easily run a number of weeks. So you multiply that by 43, and you've got a trial that could run years, even with what looks like a narrow and focused case. So I suppose those are the sort of benchmarks that we should have in mind. And on the point about evidence, yeah, again, international criminal tribunals are not magical, and they have difficulty, in my observation, succeeding without the cooperation of territorial authorities. It's very difficult to gather evidence in a compelling fashion if you don't have local support. And that was one of the other weaknesses in Cote d'Ivoire, again, compounded, as I recall, by that electoral violence situation. But, you had questions being raised by the judges about, well, what was the chain of custody on these documentary records? How do you know that the opposition parties didn't pre-fillet these files before you were allowed access to them? And you weren't allowed to remove the originals. We've only got photocopies, and some of those photocopies are of very poor quality. So you have all of those issues in the mix as well. Ross?
I think this is where the importance of prior documentation or contemporaneous documentation finds its importance now, in terms of establishing the chain of custody of certain evidence, the integrity of certain testimonies. I think the Philippines has learned a lot from its prior experience during the martial law period. As I've mentioned at the beginning, I worked in the reparations board, and this is one legal issue that we have repeatedly encountered since the mass atrocity event happened 40 years back in time. We don't have the luxury of having original affidavits, for instance, to assess and to probe for their evidentiary value. We do have that in the drug war. I think we have a robust collection of evidence that would hopefully at least compress a bit of the protracted time that it usually takes for the ICC to assess all of the evidentiary material. And I think one point to note in terms of the existence of the policy and the pattern of criminality in the Philippines, it's all on official documents. You have Command Memorandum Circular 16, which has been challenged in the Supreme Court using the word neutralize, which was cited in the arrest warrant to refer to the modus operandi of the Philippine National Police with respect to drug suspects. It's all on official government documents. And I think also the pretrial chamber cited the fact that Mr. Duterte's pronouncements to kill and reward those who will kill in his name are all documented and, in fact, found in the repository of the executive branch of the government in their website. So the evidentiary material is quite solid. I think less of a hurdle in terms of proving the integrity of these documents. Of course, witness tampering, intimidation will be a separate matter altogether.
Well, we also have the quite helpful pronouncements of President Duterte in office, which sound an awful lot like a confession or incitement. So, I mean, I suppose it's open to defense counsel to attempt to say, this is the hyperbole of a populist politician, but nonetheless. Priya, did you have something you want to come in on?
Yeah, one very, it was an interesting point that Jeffrey Nice raised in a BBC interview while the Duterte sort of arrest was unfolding. And he basically said, look, there are now obviously, greater chances of cooperation as well. But the interesting point that he brought up was sort of this potential then for the government of the Philippines to be over enthusiastic and to be sharing evidence or, maybe oversharing or even fabricating some of it. And so for the court to be careful and I would say potentially go with what has already been submitted and who they've been working with, maybe slightly independent of government channels as well, for fear of that taint, because everybody knows the political sort of environment and the context in which this is coming from. So that's a bit tricky, I think. I mean, you do want cooperation, you do want to be able to enter the territory, and you do want to have access as well. But I guess that will be for the court to negotiate in terms of how it manages the optics and how it manages, its continuing relationship also with civil society and some of the other actors. So just something that I thought was very interesting and would be good to raise.
Yeah, no, and if I recall correctly, that was an issue in Côte d'Ivoire as well, wasn't it? That the judges kind of said, well, if all of this evidence is being given to you by the people who impart through this defendant out of power, how reliable is it? How much can it be corroborated by other sources? Look, before we start to wrap up, we have seen Duterte appear in the ICC and his counsel make opening arguments, and I've only read the transcript rather than watch the live recording, but there appeared to be a number of interesting moments there in terms of exchanges between bench and bar. Is there anything either of you would like to reflect on coming out of that?
Well, for me as a spectator watching at the time, and when his counsel during the initial appearance, Mr. Medialdea, who was his executive secretary when he was president, suddenly said we would like to have a manifestation and said this speech that really sounds like a litany of complaints against the Marcos government, saying this is all a political ruse to pin Mr. Duterte because of some political ambition by certain people in power. Well, for one, the observation, at least on my end, that sort of flair for the dramatic, for a lack of a better term, is quite telling of how the Duterte presidency and the people who are still loyal to him have managed this all along, trying to sway the public opinion in favor of Mr. Duterte. And we have seen that. Again, I've mentioned a while ago how throngs of protests in support of Mr. Duterte have mobilized all throughout Europe and in other parts of the world where there is a considerable community of the Philippine diaspora rallying behind Mr. Duterte. So while in terms of courtroom decorum, it's another thing, or in terms of procedural finesse, we may raise our eyebrows on that, especially from the point of view of international lawyering. for the Filipino public and for the Filipino people who are still supportive of Mr. Duterte, this is quite potent, politically speaking. So legally, no weight, but the political effect of it, quite powerful.
Thank you. That's helpful. Priya?
Yeah, I mean, I would just say exactly that the optics of these arguments are important, sort of the performative effect, apart from sort of the legal. But of course, the questions around jurisdiction. I mean, I think it's quite clear that there are going to be jurisdictional challenges, but that is for later. I mean, I think this first appearance was, I think, very significant for the court in the context that it is in right now. I think very significant for Asia Pacific in general. We have, Afghanistan, we've got Myanmar, we've got a lot of conflicts and a lot of, mass atrocity crimes in the region. And I think it's important that this is the region that has had the lowest ratification of the Rome Statute. That is honestly one of the toughest regions to advocate for, ratification of the Rome Statute, to advocate for state responsibility, international criminal responsibility. We don't have regional mechanisms that are effective, unlike, the African Court or the European Court, Latin American Commission. So I think that this is an important moment also for the Asia Pacific region in what it means, in the sense that, accountability is possible and that no one is immune and no one is above the law. And I think that is an important message, just even from this first appearance before the court.
Thank you for that context. Ross?
Yeah, and just one more point on what this means to the victim community. That has been a talking point that was sorely lacking in the past 2 weeks. Where's the victim community in all of this? Because as Priya has mentioned, this wouldn't be possible without the brave efforts of all the lawyers, journalists, the victim advocates, and the families of the victims themselves to just write this down, submit it to the court as communications, and here we are now. So I think that in terms of, for all our critique of the ICC politically, its track record has not been this good when it comes to heads of state, or that justice in The Hague is not the same as justice at home. But I think the articulation of justice for the victims is something that we shouldn't ignore. And if international criminal justice for the victims right now would be the best articulation of accountability, that is something we have to listen to.
No, thank you. Although, again, that the ICC's relationship with victims is not always straightforward, but that's probably a subject matter for another podcast. Now, in closing our discussions, we usually ask our guests for any recommendations they might have for listeners who'd like to know more about the topic. So what's one thing each of you might like to bring to readers' attention, or one or two things?
Well, I think one is, the sort of investigative journalists at Rappler. So Rappler is an online, it's a media outfit that has sort of survived the Duterte years despite severe criticism and sort of cases against the person who ran it and established it, Maria Ressa. So I think if you want to look at the past track record, you want to look at what has been reported over the years, I think they're a great source. Also, let's not forget that during the time that Duterte was mayor in Davao, a lot of rights groups, including the Commission on Human Rights, Human Rights Watch, and when I say Commission on Human Rights, I mean the Commission of Human Rights in the Philippines, have all worked and come out with reports, come out with statements. So there's a lot in the past that you can still look at that has been talked about, linked to what then unfolded in 2016.
I'm not sure if the Ateneo project on the drug war archive is still up, but I think it should still be up. It's the early years of Duterte that they documented. So this is a good snapshot of how the horror, so to speak, unfolded in those early days, and what could be the possible patterns in terms of the victims and the modus operandi of the perpetrators. It could still be there, the Drug War Archive project of Ateneo de Manila University and the Research Consortium. Also, the Commission on Human Rights, we came out with the report in ICV because I was part of the initial formulation of that report. It's on the CHR website, just to show what are the different geographical areas that were hotspots, the time periods, the spikes, as well as a glimpse into the incentive system. It's there. but it covers up until 2022, I think, or no, sorry, 2021. And then also a lot of features on the frontliners of the drug war, like Father Flavi, who's a priest who provided sanctuary for the victims. A lot of features on him. In terms of films, we have Aswang, that's the title, on the president's orders. So these are the documentaries that might be available free to view online on the drug war.
Thank you very much. Priya, yes.
One last suggestion, and it's on my to-read list. I have not read it yet, but I've ordered it. There's a book called Some People Need Killing by Patricia Evangelista, a journalist based in the Philippines. I've read reviews of it. It seems like it gives a good overview of what happened, but disclaimer, I haven't read it myself, but I plan to.
Super. Thank you. Usually we try and end these episodes on a slightly lighter note, particularly when we've been dealing with subject matter like that we have today. And we usually try and make it a non-international law question. So on season 2, we've been asking guests, who is one of your favorite obscure or underrated characters in fiction, and why do they speak to you?
Ross, do you want to go for it?
Probably Wedge Antilles of the Star Wars universe. I mean, not that obscure, but he was a minor character. Only because he's so cool and he has been there since episode 4 and has some of these appearances in the other films. So probably him.
Always good to meet another Star Wars fan, but I'll pivot away from. I know this is sacrilege. Like, people are either Star Wars or Star Trek fans. I'm both. And I will say that Uhura, sort of the communications officer in Star Trek, and she's not underrated. Let's face it, and she's not obscure. She was fantastic. I think she certainly deserved maybe her own spin-off or her own series. But can I just say, and I was thinking about it, and this maybe is really obscure. When I was a kid, I loved watching and I loved reading Winnie the Pooh. And, everybody focuses on Winnie and on Tigger the tiger. But one of the characters that I loved was Eeyore, who's this little sad donkey who was a real sweetie pie, who was really compassionate, a bit down in the dumps all the time. But there was something about Eeyore that spoke to me, and I would actually write poems about him. So yeah, maybe I'll go with Eeyore for this one.
Oh, terrific. No, the answers we get to this question are always really interesting, and I'm glad to have other sci-fi fans on the call. But yes, I think with Winnie the Pooh, Rabbit always spoke to me, but that perhaps speaks to my slightly high-strung nature in terms of the kind of lexicon of personalities we can break out of Winnie the Pooh. But that is all we have time for. But Ross and Priya, thank you so much for taking the time to speak with us and share your expertise. It's been terrific to have you on.
Thank you very much, Douglas, and lovely to meet Ross finally after a long time.
Thank you. I've been following you both on Twitter for how many years now? So nice to finally be on a call with you both.
All right. Well, thank you, everyone, and bye-bye.